Welcome to our panel discussion, which will focus on what do you do if you're asked to testify, produce documents, or are subpoenaed as a mediator. More and more mediators have faced these issues. We will tell you about our experiences, we'll consider the practical implications, provide you with some helpful forms and some tips on how to best address these issues upfront. It is my privilege to participate in this presentation with co-panel members Shari Elisar and retired Judge Lester Langer. By way of background, I have been a mediator since 1989 and served as a former chair of the ADR section of the Florida Bar, former president of the Florida Academy of Professional Mediators, and served on the Florida Supreme Court Mediator Ethics Advisory Committee. I also served on the Florida Supreme Court Committee on Alternative Dispute Resolution Rules and Policy. And when I was on that committee, we were involved in drafting the Mediation Confidentiality and Privilege Act, which I'm going to talk about today. I'm an approved circuit and family mediation primary trainer and an approved trainer for Florida Supreme Court qualified arbitration trainings. For many years, I was a mediator with Mediation Firm, Inc., now Florida Mediation Group. Shari, would you introduce yourself?
Thank you, Mia. My name is Shari Elisar. I'm the founder of Back on Track Mediation. I'm excited to partner with two wonderful mediators and arbitrators, brilliant, exciting people. Mia Tell, who's also an esteemed primary trainer in mediation and arbitration, and a co-chair with Deb Maston of the Biannual Arbitration Advocacy Institute, and very happy to be here with the Honorable Lester Langer, who served for over 20 years on the bench in Miami Circuit Court. We all served together, the three of us, on the Executive Council of the ADR section of the Florida Bar. An event like this takes a lot of work. And I want to say thank you to Tad David, Mary Beth Bohannon, Kimberly Kosh, Dawn Burleson, Sherry Waits, who's retiring this year, Raymond Waters, Dewada Thomas, Stephanie McCarty, Shona King-Denard, and Stephen Bonda and Company. And special thanks to Jeremy Isaacson, who is filming us right this moment. We are very happy to be here at the DRC conference to share with you, first, a global understanding of the scope of confidentiality. We're going to do sort of a high-level academic review of that, where it applies, where it does not, and then we're going to dig in and discuss how to deal with a subpoena to protect yourself and the mediation process, not just yourself, but the process. My legal expertise includes commercial, business, and technology issues, personal injury, consumer products, real estate, and construction law. I am a member of both the Florida and New York bars, a former Wall Street commercial litigator for Cravath, and former in-house counsel managing litigation to multi-billion-dollar corporations, including regional general counsel of Suffolk Construction. They built the Hard Rock Hotel, the Guitar Hotel in Fort Lauderdale, and general counsel for Legacy Acquisitions, a property development group. I am an entrepreneur as well, and one of the founders of a software company called Dason LLC, also known as Apparel Magic. I spend a lot of time with my volunteer work, which includes participating with the state and federal courts in their civil discourse outreach program with local teens, volunteering as a guardian ad litem, lecturing at Palm Beach State College, judging and coaching with Nova Law School's moot court and NTA events, and mentoring and educational outreach events like these. Lester, it's your turn.
Okay, thank you both. I appreciate it. Thank you, everybody, for being here. I've been a mediator since 2013 when I was certified as a circuit civil mediator after being a judge in Miami-Dade County for 20 years. I also became certified as a senior judge in 2013 as well. Before that, I practiced law for 21 years. I now mediate through Salmon and Dahlberg dispute resolution since 2014, and I am a member of the executive committee of the ADA section of the Florida Bar. I am very honored to be here today, joining my colleagues, Mia and Shari, and sharing with you some insights regarding confidentiality and privilege communications at mediation. If any of you have any questions, please put them in the chat. And throughout this session, we will try to answer them back to you through the chat as well. So check that periodically. Thank you for joining us today. And Mia, I'm turning it back over to you.
Thank you, Lester. Let's begin at the beginning. The Florida Mediation Confidentiality and Privilege Act. This is the statutory provision that governs mediation confidentiality and privilege in Florida. The statute is 44.01 to 44.06. When you're asked to testify or you get a subpoena, these are the important questions that a mediator should ask. The first is this mediation covered by the Florida Mediation Confidentiality and Privilege Act? The statute only applies to certain mediations. So the first question is, does it apply to the mediation that I've been asked to testify about? The statute applies to mediations that are required by statute, court rule, agency rule or order, oral or written case-specific court orders, or court administrative orders. And those are the ones we're probably most familiar with. The statute also applies to mediations that are conducted under the Mediation Confidentiality and Privilege Act by the express agreement of the parties. It covers mediations facilitated by a Florida Supreme Court certified mediator, unless the parties agree not to be bound by the Mediation Confidentiality and Privilege Act. The mediation parties can also agree in writing that any or all of the provisions of Chapter 44.404, which relate to mediation confidentiality and privilege, and 44.406, which relates to remedies for disclosing mediation communications, don't apply to all or part of a mediation proceeding. The second question is, are you being asked to testify as to a mediation communication? Because that's what the statute protects. What is a mediation communication? It's an oral or written statement or a nonverbal conduct intended to make an assertion by or to a mediation participant during the course of a mediation or prior to mediation if it's made in furtherance of a mediation. The commission of a crime is not a mediation communication. So that's a really important question to ask. And we're going to talk more about trying to find out what is it exactly that they want us to testify to. The third question to ask is, if you've decided that you're being asked to testify about a mediation communication, did the communication occur during the mediation or prior thereto in furtherance of the mediation? So what's really important to figure out is, did this communication occur during the mediation? So the statute tells us in court-ordered mediations, the mediation begins when the order is issued by the court, not when you're selected as the mediator, but when the court order of referral is issued, and ends when a partial or complete settlement agreement intended to resolve the dispute is signed by the parties, and if required by law, approved by the court, or when the mediator declares an impasse by reporting to the court or the parties the lack of an agreement, or the mediation is terminated by the parties' agreement or by one party giving notice to all other parties in a multi-party mediation that that party is terminating its participation in the mediation. Under that circumstance, the termination is effective only for the withdrawing party. What about all other mediations? They begin when the parties agree to mediate, or as required by agency rule, agency order, or statute, whichever occurs first, and again ends when there's a partial or complete settlement agreement intended to resolve the dispute and end the mediation signed by the parties, and if required by law, approved by the court, or the mediator declares an impasse to the parties, or the mediation is terminated by court order, court rule, or applicable law, or the mediation is terminated by agreement of the parties, or again, in a multi-party mediation, by one party giving notice that they're terminating their participation in the mediation. And the termination, again, is effective only as to the withdrawing party. So once there's a court order referring a case to mediation, any discussions with the mediator or between counsel for the parties regarding the mediator serving as the mediator, or with the mediator initially about the case, asking the mediator to serve, are confidential communications. The next question is what's the importance and what's the difference between mediation confidentiality and mediation privilege, and why does it even matter? Well, the statute discusses confidentiality and explains that except as provided in the exceptions in 44.405, all mediation communications shall be confidential, and a mediation participant shall not disclose a mediation communication to a person, other than another mediation participant or a participant's counsel. And participant is defined as a mediation party or a person who attends a mediation in person, by telephone, video conference, or other electronic means. And we know today a lot of us are mediating virtually, so we have a lot of electronic participation. It includes, the term mediation participant includes the accountant, the actuary, the realtor, the interpreter, people who appear at the mediation conference. And 44.405 tells us that if there's a violation of this section and a mediation participant discloses to a third party what happened at mediation, that a violation can subject the mediation participant to sanctions by the court, including but not limited to costs, attorney's fees, and mediator's fees. Privileged communications are different because privilege relates to communications at mediation that you're seeking to reveal in a subsequent adjudicatory proceeding, which the statute defines as also including related discovery. More specifically, the statute says a mediation party has a privilege to refuse to disclose and to prevent any other person from testifying in a subsequent proceeding regarding mediation communications. Privilege in Florida is held by the parties and not the mediator. In many other states, the mediator holds the privilege. Not so in Florida. Since the privilege applies to related discovery following mediation, we know that it also applies to you, the mediator, being subpoenaed to testify in a deposition. Shari, can you discuss for us some of the exceptions to mediation confidentiality and privilege contained in the statute?
Thank you, Mia. Well, we mediators, if you've done it 20 times or 2,000 times or 20,000 times, will be familiar with this phrase, unless required or permitted by law. We qualify our confidentiality. We know mediation communications are confidential unless required or permitted by law. Well, what does that mean? As it turns out, 44.405 actually has 6 specific enumerated exceptions. There's actually 6 of them, and I'm going to tell you what they are. Number 1, for which confidentiality or privilege has been waived by all the parties. So guess what? If anybody wants their privilege protected, now you've got an issue. But if they don't, if they've all waived it, go testify. Number 2, mediation communications that is willfully used to plan a crime, commit or attempt to commit a crime, conceal ongoing criminal activity, or threaten violence is not protected. Surprise, surprise. Well, believe it or not, before these enumerated exceptions, that was not an exception. And as Mia was telling us before, courts were doing somersaults trying to figure out how to get people to be allowed to talk about criminal activity. Well, that's not a problem anymore. You can do it if it has to do with criminal activity or threatened violence. Number 3, we talked about required or permitted by law. This is required by law. If you are dealing with abuse and neglect of children or vulnerable adults, you must report it. These mandatory reporting requirements are pursuant to Chapter 39 and Chapter 415. Now, I want to be very clear here. Although you were required to report it, you are only required to report it for the purpose of making the mandatory report required by law. You do not have now free reign to talk about it. It is still mediation confidentiality. These exceptions are very narrow. So understand that just because it is an exception doesn't mean it is a broad exception. It is a narrow exception. Moving on. If there is professional malpractice occurring during the mediation and there is a subsequent professional malpractice proceeding, you may testify to report, prove, or disprove professional malpractice. Again, solely for the purpose of the professional malpractice proceeding. You still have mediation confidentiality, and the exception is just with respect to that proceeding. Number 5, also offered for the limited purpose of, and listen to this carefully, establishing or refuting legally recognized grounds for voiding or reforming a settlement agreement reached during a mediation. This is a very oft confused section. Many mediations end without signing an agreement, but the parties believing they have come to an agreement. But a mediation settlement agreement does not exist unless it is reduced to written form and executed. And interestingly enough, in other areas of the law, you can have a verbal agreement, but not in mediation. Mediation spells out very specifically that it has to be executed by the parties. This particular exception is for the limited purpose of voiding or reforming an existing settlement agreement. What does that mean? Well, maybe the parties didn't have authority to sign. Maybe there is something in the actual document itself that is just plain wrong, and we need testimony to reform the agreement to conform with what the parties agreed to. This is only for existing settlement agreements. It has nothing to do with proving that an agreement was reached, which more often than not, people try to do in mediation, and they cannot, because if it's not executed, it's not an agreement. And finally, number 6, again, solely for the internal use of the body conducting the investigation of the conduct. This has to do with professional misconduct. If you need to offer to report, prove, or disprove professional misconduct, you may testify solely for the internal use of the body conducting the investigation. Now, there's a few more things I want to mention about mediation confidentiality. These are just practical limitations about it. Number 1, just because something is confidential in a mediation doesn't mean it is confidential for any other purpose. An example would be information that is otherwise admissible or subject to discovery does not become inadmissible or protected from discovery simply because you brought it out in mediation. Obviously, you can't do fruit of the poisonous tree. You can't discuss what you're doing in mediation or how that document was produced or used, or even if it was. But if it was independently admissible or subject to discovery, it still is. Also, and these are also under 44405, a party that discloses or makes a representation about a privileged mediation communication waives that privilege so that the other party can respond to the disclosure or representation. So if somebody wants to say something happened at mediation, you don't have to abide by the mediation confidentiality while they've violated it. Once they've violated, you have the right to respond, but again, limited to the extent necessary for that response. That being said, I'm done with the exceptions to mediation confidentiality, and I'd like to turn it over to Lester to tell us, we've done all of this academic discussion about mediation confidentiality. Tell us what to do when that subpoena comes through.
Okay, here we go for some of the practical stuff. Okay, you get the knock on the door, or someone comes to your office, or somebody taps you on the shoulder in a restaurant and hands you a piece of paper and says, you're served. You know, what do you do? So first thing to do is don't panic. Okay, do not panic. Don't lose your temper. Don't punch out the process server or anything like that. Okay, stay calm. Take a deep breath. Count to 10. Okay, do anything you can to kind of calm down. And once you do, start to think, what should I do now that I've gotten this subpoena? If you are in a mediation firm like I am at Salmon & Dahlberg, call somebody at the mediation firm. Find out if they have any policies or had any experience dealing with one of their mediators who may have gotten subpoena in the past. Is there some kind of firm policy that deals with that situation? If you are on your own or in a small firm that doesn't have any policies, then pick up the telephone, call the attorney that subpoenaed you. Find out what is going on. What's the nature of this subpoena? Is it for a hearing? Is it for a deposition? Or something along that line? You want to kind of find out what's going on so that you can be prepared. Find out if anybody has signed a waiver or if waivers have been signed by everybody, because then you don't have any particular problem. At that point, you're free to testify as to those things that Sherry just said relative to what happened at the mediation. But if there are no waivers, you got to try to find out what's going on. Try to narrow what the issue is so you have an idea of where you might have to testify. Get as much information as you possibly can from the attorney that subpoenaed you. Once you have all that information, call the other side. Find out what the other side of the story is. Are they the ones that are bringing this forward? Or is the guy that subpoenaed you or the attorney that subpoenaed you are the ones that want to bring something forward? Kind of find out what's going on. But above all, once you get all that together, do not panic. So I'm going to throw this over to Sherry. Sherry, what would you do?
Well, the first question you need to ask for yourself is whether you need to get an attorney or whether you're going to do this alone. MEAC, which is the Mediation Ethics Advisory Council, advises the mediator to consult with an attorney, regarding the statutes and the court rules, all the stuff we're talking about today, relevant to the practice of mediation, as well as the possible legal consequences of refusing to testify regarding confidential mediation communications. That being said, not everybody wants to go and hire a lawyer or wants to pay for a lawyer. So one of the things that you need to think about is whether or not you have a mediation agreement or some other document that's acknowledged or signed by the other parties that basically says if they issue a subpoena to you, they're going to pay you for your time, or if you have to hire a lawyer, they're going to pay you for your legal fees. And that's a very proactive thing to do. It really just depends on what kind of documents you're using and how much thought you've put into it. But you have the choice to hire an attorney or not. There's no rule that prohibits you from filing a motion to quash or a protective order on your own. You're not obligated to file a motion to quash You can just show up and object in person. And the relevant rules are 44.405 of the Florida statutes and Rule 10.360 governing court certified and court appointed mediators. But you can do it on your own, or you can do it with a lawyer. Now, if you are going to be super prepared, understand that there are certain things you can do in your mediation agreements and certain things that you cannot do. There's a MEAC opinion 2017-007. And again, this is advisory. This is not a statute. This is not a law, but this is advisory. And what they say is it's not ethical for a mediator's confidentiality agreement to include a provision that the parties in counsel agree not to subpoena the mediator for future legal proceedings. So you really can't contract out their ability to issue a subpoena. They can issue one. Whether it's enforceable, whether you'll have to testify is another issue. That same opinion also says any confidentiality agreement must not remove the right to waive confidentiality and interfere with self-determination under 10.310. And finally, a confidentiality agreement cannot state that the parties agree that all matters discussed during the mediation are confidential and cannot be used as evidence in any subsequent administrative or judicial proceeding. Now, understand this is about a confidentiality agreement, but you can have confidentiality provisions in any agreement. So if we look at MEAC, there are certain things we cannot negotiate out. But to the extent that we can do certain things to protect ourselves, one of them would be to build in an attorney fee provision and build in a mediator, mediator cost provision to pay your hourly rate for your time if you do get subpoenaed. And then maybe they won't want to subpoena you so much. I am going to turn it over to Mia and ask how you would handle it.
Thank you very much, Sherry and Lester. I believe in putting things in writing as much as I can. So I would ask the party subpoenaing me or their counsel for detailed information about what they want me to testify to and what they want me to produce. Similar to what Lester said. What is it exactly that they want me to do? And if the party or their counsel say that there's a written waiver from the other party, I would ask to see it. And then I would contact the other side and ask them if in fact that was their written waiver, and ask them to confirm that to me in writing. Sometimes you may believe that what they're asking you to testify to really falls under an exception, and there is no confidentiality. If that's the case, maybe what you want to do is write to the parties and their counsel, discuss your analysis, and see whether they agree. I will tell you there was one case that I was involved with that involved a Scrivener's error, and unfortunately I was a Scrivener. So counsel for the party that wanted that error to be corrected, of course, was happy to waive mediation, the mediation privilege. And the other side, the other attorney, who knew that there was a Scrivener's error, was basically told by his client that he could not waive the privilege on behalf of the client. He wanted to benefit from the Scrivener's error. His attorney was not happy about that, but he indicated to me that the client would not allow for a waiver. So I went to court and the judge ordered me to testify and corrected the Scrivener's error. And I think we can all agree that that falls under the exception that Sherry talked about, which is reforming an agreement, because it really did need to be reformed and there was an error. So that's just one example of where sometimes, we are ordered to testify, and appropriately so. Okay, Lester, if talking to the parties, their counsel, doesn't really help the situation get worked out or resolved, what would you do then?
Well, we've talked about this before. Sherry mentioned you might want to consult an attorney. Find out what your options are. Find out whether you're within compliance within the rules, make the determination based on the information you got, what they want you to really do.